Barnette case takeaways are vested in 4 areas. Number 1. Coercion and compulsion is no proof of loyalty. It only means one used state police powers and threat of punishment to satisfy one's own self-interest that the state is supreme and we citizens are mere expendable cogs in the state machinery. For true patriotism and love of country spring from free minds and willing hearts, because that is the origin and founding of this American Republic when it overthrew prior British imperial rule upon the American colonies. Number 2. The individual is the center of society, not kings, queens, noblemen, aristocrats, just simple, ordinary, mom-pop family human beings. For U.S. legal philosophy, liberty is attained at absence of governmental controls, or at a bare minimum requirements thereof. The more excessive control by government in our daily rigors can only lead to diluted constitutional rights and self-determination of our daily lives. Number 3. Free public education must be secular. No prerequisites be imposed on political, religious, social grounds for educational entry, and no compulsory activity against one's conscience as vested by constitutional rights. Thus, ensure free flow of education and information across entire spectrum of society and national general welfare. Number 4. Supreme Court justices can make mistakes. The High Court justices are mortal beings, and human beings do make mistakes. In the past, High Court had interpreted the Constitution that compromised individual liberty and granted too much power to the state, all in the name of public order and national security. Thus, they had to rectify their own judicial errors and failings. For example, this 1943 Barnette case overturned prior 1940 Minersville case, followed by 1944 Korematsu case, by which U.S. Supreme Court ruled that in times of war, state police powers can use general racial criteria to prosecute the war effort, thus resulting in 125,000 Japanese Americans being forced at gunpoint to American concentration camps, or, if you prefer a more PC title, internment camps. The Korematsu case precedent was overturned some 40 years later in 1980s, when High Court issued a rare writ of coram nobis, that's Latin for before us the court, followed by this case is never to be held as precedent in future cases. Coram nobis is a High Court order to correct its original judgment upon discovery of a fundamental legal error that did not appear in the records of the original judgment proceedings and would have prevented the judgment from being pronounced. In fact, the next potential Supreme Court rectification of prior judicial error to watch for is 2005 Kalo versus City of New London, involving state eminent domain transfer of private property not for public good, like building public school or highway, but court-sanctioned state forcible transfer of private property for private good, as in giving corporations right to seize private property using state police powers, since it will overall increase the tax revenue base of the city. This Supreme Court decision was so egregious that state governments rushed to amend their own state constitutions that one cannot use eminent domain power to seize private property for private good.